A question I get a lot as a wills lawyer is, why do I need a will if I don't really own anything? People will tell me, I don't have any kids, I don't own my home. What do I really need a will for? And what I always tell them is, well, you are a being, and so you need to have a will. One of the things that a will does is appoint an executor. And one of the responsibilities of that executor is to make the final decision about what will happen to the body of that person after they pass away. So the executor is the one that will give instructions to the funeral home if there's going to be a funeral, for burial, for cremation, that sort of thing. So it's a good thing to remember that if you do have a will, make sure your executor knows what your preferences are if you haven't already let them know, or if you haven't pre-planned your funeral. So that's number one. A will appoints an executor. An executor, or an estate trustee, as it's known in Ontario, is someone that has authority to act on behalf of the estate. And so people who tell me, they don't own their home, they don't have any children, they usually have a bank account. They usually have some sort of online presence. They usually have a car. And so all of these things are actual assets that need to be dealt with once someone has passed away. Even if there's not a lot in those bank accounts, there's maybe something there that could be used to cover the costs of a funeral, that sort of thing. And so what your will does is it names a person as an executor. That person then has the authority to go to the bank and deal with those accounts. Call your cell phone provider and cancel your cell phone. Deal with your online assets and sell your vehicle. And again, they also have the right to deal with your final remains and whatever ceremony, or maybe you don't want a ceremony at all, the executor has the authority to be able to make those decisions. If there's no will, then there's no executor named. That means no one has the authority to be able to even go to a bank and say, hey, did this person who's passed away, did they even have any accounts with you? The bank often won't even talk to that person or answer those questions because they have no assurances that that person isn't just coming in when they shouldn't be. And so the will gives a piece of paper, some authority to that person to make those decisions and to deal with those assets. So really, the most important thing a will can do is name an executor. The second thing a will does is it will name your beneficiaries. So it's not true that if you die without a will, the government gets everything that you own. What is true is that if you die without a will, the government, legislation, so law, says who is your number one beneficiary if they've passed away, or if you don't. So if you are married, that's your first beneficiary. If you don't have a spouse, then it would be children. If you don't have any children, then it's parents if you've lived, and if they're living. And if there's no parents, then it's siblings, and on and on and on. The only time that you see the government getting everything is if a person has absolutely no kin or no relations. And so I always tell my clients that a will does two basic things. It says who's in charge and who gets what. And even if you don't have major assets, those are two really important things that should be decided by you. It is something that doesn't take a whole lot of time. It's not as complicated as it seems. And at Anderson Law Group, we work with you to make sure that it is a comfortable process and that at the end you're confident with the results that you get. So contact us and we will work through whatever you've got to get you where you need to be.